Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today, ladies and gentlemen, we'll provide another installation to our Anti-Federalist Papers series going on number 60. So if you haven't gone back and watched 1 through 59, I would highly encourage you to do so because understanding the Anti-Federalist Papers, in addition to the Federalist Papers, will provide you a very well-rounded understanding of the U.S. Constitution, and understanding the U.S. Constitution will be absolutely necessary if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. The version I'm using is provided by the constitutionalistsociety.com, but there are multiple institutions from which you can get a paper and digital copy of the Anti-Federalist Papers. Go ahead and get both. While you're out there looking, if you haven't done so already, go ahead and get a copy of the Federalist Papers so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. So number 60 is titled, Will the Constitution Promote the Interests of Favored Classes? This is from John F. Mercer of Maryland, was the author of this essay, taken from his testimony to members of the ratifying conventions of New York and Virginia in 1788, from the Edding Collection of the Historical Society of Pennsylvania. So Mr. Mercer says this: We have not that permanent and fixed distinction of ranks or orders of men among us, which unalterably separating the interests and views, produces that division in pursuits which is the great security of the mixed government we separated from, and which we now seem so anxiously to copy. If the new Senate of the United States will be really opposite in their pursuits and views from the representatives, have they not a most dangerous power of interesting foreign nations by treaty to support their views? For instance, the relinquishment of the navigation of the Mississippi, and yet where treaties are expressly declared paramount to the Constitution of the several states, and being the supreme law, the Senate must of course control the national legislature, if not supersede the Constitution of the United States itself. The check of the President over a body with which he must act in concert, or his influence and power be almost annihilated, can prove no great constitutional security. And even the representative body itself are not sufficiently numerous to secure them from corruption. For all governments tend to corruption in proportion as power concentrating in the hands of the few tenders them objects of corruption to foreign nations and among themselves. For these and many other reasons, we are for preserving the rights of the state governments where they must not be necessarily relinquished for the welfare of the Union. And where so relinquished, the line should be definitely drawn. If under the proposed Constitution the states exercise any power, it would seem to be at the mercy of the general government. He's talking specifically about Article 1, Sections 9, 10, and then Article 9 and 10 to the Bill of Rights in the U.S. Constitution. Article 9 and 10 to the Bill of Rights say, every single power exercisable by the general government is explicitly listed here. Every power not listed is retained by the states, not given back to the states because the states always had the power in the first place. They are retained, they are preserved, they are maintained in the state. Not given, not restored, not revived. The states have always had the power, always. Article 1, Section 10 says exactly what the states can't do, which is 3 or 4 different things, 3 or 4 different powers. Everything else the states can do. For it is remarkable that the clause securing to them those rights not expressly relinquished in the old Confederation is left out in the new Constitution. And we can see that there is no power which Congress may think necessary to exercise for the general welfare which they may not assume under this Constitution. And what do you hear as the justification for all overreach? Necessary and proper clause, while providing for the general welfare, necessary and proper clause. And this Constitution and the laws made under it are declared paramount even to the unalienable rights which have heretofore been secured to the citizens of these states by their constitutional compacts. Moreover, those very powers which are to be expressly vested in the new Congress are of a nature most liable to abuse. They are those which tempt the avarice and ambition of men to a violation of the rights of their fellow citizens. Good grief, gotta untie my tongue. And they will be screened under the sanction of an undefined and unlimited authority. But don't worry, James Madison said. Necessary and proper means proper under the U.S. Constitution, and necessary only provides for what is proper under the U.S. Constitution. So we don't have any worries and concerns. And besides, even if they do go outside the constitutional limits, the state legislatures and the state governments will act as a barrier against the federal government, says James Madison in the Federalist Papers. How true is that? How true did that become? Nil. Which is why not much later, after the U.S. Constitution was implemented, not ratified, implemented, imposed, Madison joined Jefferson and Mason and Patrick Henry in dissenting against the U.S. Constitution. Basically, the author, he's referred to as the father of the U.S. Constitution, but without his efforts, without his constant criticism of the Articles of the Confederation, the convention probably wouldn't have been called. Realistically, he is the author of the U.S. Constitution. When the father of the U.S. Constitution says the Constitution is a bad document, it's probably worth taking his word for it and seeking to replace it with the significantly better, significantly more liberty-oriented document, oriented government, that being the Articles of the Confederation. They are those which tempt the avarice and ambition of men to a violation of the rights of their fellow citizens, and they will be screened under the sanction of an undefined and unlimited authority. Against the abuse and improper exercise of these special powers, the people have a right to be secured by a sacred declaration, defining the rights of the individual and limiting by them the extent of the exercise, a Bill of Rights. The people were secured against the abuse of those powers by fundamental laws and a Bill of Rights under the government of Britain and under their own constitution. That government which permits the abuse of power recommends it and will deservedly experience the tyranny which it authorizes. For the history of mankind establishes the truth of this political adage, that in government, what may be done will be done. Brilliantly put. Go ahead and highlight that. What may be done will be done. Do not ever assume, don't ever let your ignorance, naivety, and trusting better nature presume that the government, any form of government, Republican, monarchical, democratic, tyrannical, authoritarian, centralist, decentralist, whatever form of government, do not ever think it is on your side, because whatever tyrannies, whatever energetic, despotic ambitions that a government could have, it will develop. Always, always, always be skeptical of the government. Always be unhesitant, be directly diligent in making sure your government is continuously, perpetually restrained by whatever means necessary. And that is almost verbatim what Madison said. Madison, Algernon Sidney, Thomas Jefferson, you name the founder, they said it. The duty, the obligation, the responsibility is on you, the citizen, to make sure the government never attains the powers necessary to exercise whatever will they so deem. And don't ever, ever for one instance think any government is for your benefit. It will always seek to subvert your rights. Every single time, every single instance. There is no government that has proven to the contrary. The most blind admirer of this Constitution must in his heart confess that it is as far inferior to the British Constitution, of which it is an imperfect imitation, as darkness is to light. In the British Constitution, the rights of men, the primary object of the social compact, are fixed on an immovable foundation and clearly defined and ascertained by their Magna Charta, their Petition of Rights, their Bill of Rights, and their effective administration by ostensible ministers secures responsibility. In this new Constitution, a complicated system sets responsibility at defiance, and the rights of men neglected and undefined are left at the mercy of events. We vainly plume ourselves on the safeguard alone of representation, forgetting that it will be a representation on principles inconsistent with true and just representation, that it is but a delusive shadow of representation, proffering in theory what can never be fairly reduced to practice. And, after all, government by representation, unless confirmed in its views and conduct by the constant inspection, immediate superintendence, and frequency interference and control of the people themselves on one side, or an hereditary nobility on the other, both of which orders have fixed and permanent views, is really only as one of perpetual rapine and confusion. Even with the best checks, it has failed in all the governments of Europe, of which it was once the basis, except that of England. We turn our eyes back to the zones of blood and desolation which we have waded through to separate from Great Britain. We behold with manly indignation that our blood and treasure have been wasted to establish a government in which the interest of the few is preferred to the rights of the many. When we see a government so every way inferior to that we were born under, proposed as the reward of our sufferings in an 8 years calamitous war, our astonishment is only equaled by our resentment. On the conduct of Virginia and New York, 2 important states, the preservation of liberty in a great measure depends. The chief security of a confederacy of republics was boldly disregarded, and the Confederation violated by requiring 9 instead of 13 voices to alter the Constitution. Precisely. If you've watched the Articles of the Confederation lecture, you would already know that the Articles of Confederation, in the second to last paragraph, if I remember correctly, requires unanimous consent between the states to amend, let alone completely replace it. 70 delegates were called to the Philadelphia Convention, what we know as the Constitutional Convention. 55 showed up, only 39 voted to ratify. Failed to meet the requirement of the Articles of Confederation. Not ratified. The U.S. Constitution, not ratified. Well, Caleb, later on, 9 of the 13 states voted to ratify. 9 out of 13, still not unanimous agreement. Therefore, fails the ratification standard. And none of the states ever filed secession from the Articles of Confederation, which means they still recognized and were bound to the terms of the Articles of the Confederation. The U.S. Constitution was never ratified. It was imposed by gunpoint. It was implemented, instituted. It was never consented to. It was never ratified. But still the resistance of either of these states in the present temper of America, for the late conduct of the party here, Maryland must open the eyes of the people in Massachusetts with respect to the fate of their amendment, will secure all that we mean to contend for, the natural and unalienable rights of men in a constitutional manner. At the distant appearance of danger to these, we took up arms in the late Revolution. And may we never have cause to look back with regret on that period when connected with the Empire of Great Britain, we were happy, secure, and free. So that was quite a bit to be said in number 60, though it being short. But if you have any questions about what was said in number 60, maybe questions about what was said in the preceding papers, or if there's a topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare that will, not if, but will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.